Very good evening, everyone. After 2 successful days of insightful session, I welcome you all on this third day of Legal Aid Awareness Program for the academic year 2021-22, a webinar series Law at Your Doorstep, which is organized in collaboration with Department of Law, University of Mumbai, Department of Law, Mahatma Gandhi Kashi Vidyapith Varanasi, and Janardhan Bhagat Shikshan Prasarak Sanstha's Bhagubai Changu Thakur College of Law. We will begin our webinar by national anthem. So may I request you all to kindly stand up for the same.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे।
I, Suyash Bartake, the student of 5th year BLS LLB, feels a great and immense pleasure to indeed welcome an honorable legal luminary and a dynamic personality, Honorable Mrunalini Deshmukh Madam, Advocate, High Court, Bombay. I am also blissful to welcome another legal luminary, Honorable Shri Sudeep Pasbola Sir, Senior Advocate, High Court, Bombay, and Vice Chairman, Bar Council of Maharashtra and Goa. I am also delighted to welcome Honorable Dr. Rajeshri Varadi Madam, Professor and Head of Department, Department of Law, University of Mumbai. I am very glad to welcome Honorable Dr. Ranjan Kumar Sir, Head and Dean, Department of Law, Mahatma Gandhi Kashi Vidyapith, Varanasi. I would also like to welcome Honorable Dr. Mrs. Sheetala Shrikant Gawan Madam, Principal, Bhagubai Changu Thakur College of Law, New Panvel, Raigad. Further, I am really very pleased to welcome all other dignitaries present here, honorable principals of various law colleges, professors, teaching staff, advocates, members of alumni, student coordinators, and all the participants and students. A very warm welcome to one and all present here. Promoting gender equality is going to play a vital role in preventing violence against women. Promoting women empowerment is the most effective way to curtail such evils against the women. I would like to quote statement by Honorable Sushma Swaraj ji. There is an urgent need to tackle the ills of the society against women through the active participation of all, the men, the women, the society, the government. It is imperative to make women empowerment a people's movement. The Protection of Women from Domestic Violence Act 2005 has provided safeguard for women, but the evil of domestic violence still continues. And this can be curtailed only by women empowerment and nothing else. Hence, to know about the issue, our today's topic for the webinar is Domestic Violence Act and Women Empowerment. Now, may I kindly request Honorable Dr. Ranjan Kumar Sir, Head and Dean, Department of Law, Mahatma Gandhi Kashi Vidyapith Varanasi, to propose a welcome address.
इस कार्यक्रम का तीसरा दिन है। जैसा कि इस कार्यक्रम से जुड़े हुए सभी लोग जानते हैं कि मुंबई विश्वविद्यालय का विधि विभाग रायपुर, न्यू पनवेल का ठाकुर लॉ कॉलेज, महात्मा गांधी काशी विद्यापीठ, वाराणसी का फैकल्टी ऑफ लॉ ज्वाइंट संयुक्त रूप से इस कार्यक्रम को करवा रहे हैं। आज हम जिस विषय पे यहाँ चर्चा करने के लिए, जिनको हम सुनने के लिए हम आपस में वर्चुअल माध्यम से जुड़े हैं, जिनको हम सुनेंगे बॉम्बे हाई कोर्ट की विधिवेत्ता मृणालिनी देशमुख जी, जो आज इस कार्यक्रम की मुख्य अतिथि हैं। मैं अपने विश्वविद्यालय, भारत की प्राचीन नगरी, धार्मिक और सांस्कृतिक नगरी काशी से उनका मैं स्वागत करता हूं। इस कार्यक्रम में महोदया चीफ गेस्ट के रूप में जुड़ी हुई हैं। हम आभारी हैं। हमारे सभी विद्यार्थी, हमारे सभी संकाय के मेंबर, मुंबई विश्वविद्यालय के विधि विभाग, अन्य कॉलेज से जुड़े लोग उनको सुनेंगे और बहुत कुछ इससे ज्ञानवर्धन करेंगे। मैं बहुत आभारी, बहुत स्वागत करता हूं मैडम का। इस कार्यक्रम से जुड़े श्री सुदीप आर दास बोला जी, एडवोकेट, बॉम्बे हाई कोर्ट एवं उपाध्यक्ष बार काउंसिल महाराष्ट्र एंड गोवा का भी मैं स्वागत एवं अभिनंदन करता हूं। अपने बनारस से, अपने विश्वविद्यालय से आप भी हमसे जुड़े हुए हैं, आपका बहुत बहुत स्वागत है। मैडम प्रोफेसर राशि बराड़ी जी, जो इस पूरे कार्यक्रम जिनके नॉलेज में चल रहा है, उनका भी मैं स्वागत करता हूं। वो हमसे शायद अभी जुड़ी नहीं है, किसी कार्यक्रम मीटिंग में है। मैं मैडम का भी स्वागत करता हूं। डॉक्टर शीतला जी, प्राचार्य बीसी ठाकुर कॉलेज-ऑफ-लॉ न्यू पनवेल का भी मैं स्वागत करता हूं। लगातार मैडम इस कार्यक्रम को लेकर बहुत गंभीर हैं। सुबह से ही कई बार हमको फोन की कि सर जुड़ जाइएगा। आज हमारे यहाँ भी आरडीसी था, शोध का रजिस्ट्रेशन हो रहा था, इससे हम लोग भी अभी खाली हुए हैं। इस जागरूकता को, उनके इस एक्टिविटी के लिए उनका मैं बहुत स्वागत करता हूँ, बहुत आभार व्यक्त करता हूँ कि आपने हम सभी को जोड़ा। आज जिस विषय पे चर्चा होनी है, उस विषय पे बहुत दिनों से बहुत सारे काम हुए हैं, लेकिन जो काम हुए परिचर्चा के माध्यम पे या जिस भी माध्यम से, अब उसका परिदृश्य कुछ बदल चुका है। अभी राष्ट्रीय महिला आयोग ने विधिक जागरूकता, जिसको लीगल अवेयरनेस प्रोग्राम के नाम से हम इस कार्यक्रम को कर रहे हैं, इस तरह के बहुत सारे मुद्दों पे देश के अनेक विश्वविद्यालय, विधि महाविद्यालयों को एक एक काम दिया है। जैसे हमारे विश्वविद्यालय को एक विधिक जागरूकता से ही संबंधित वर्कशॉप कराने के लिए राष्ट्रीय महिला आयोग ने दिल्ली से मिला है, जिसपे हम 8 तारीख को कार्यक्रम करा रहे हैं। पारिवारिक संबंधों के बंधन एवं हिंदू महिलाओं के संपत्ति में अधिकार विषय पे एक वर्कशॉप के लिए राष्ट्रीय महिला आयोग ने हम लोगों को भी विधिक जागरूकता से संबंधित कार्यक्रम दिया है। 8 तारीख को हम लोग इसको करवा रहे हैं, 8 अगस्त को। इस विषय पे जिस पे आज परिचर्चा होनी है, हमारा ये मानना है कि जिनके लिए बना था उनको कितनी राहत मिली है। और हमने अभी कहा कि ये परिदृश्य बदल चुका है। अब दूसरे के साथ भी, दूसरे पक्ष के साथ भी घरेलू हिंसा हो रहा है, इस पे भी विचार हम लोगों को करना चाहिए। अभी तक हम चर्चा यही करते हैं कि महिलाओं के विरुद्ध घरेलू हिंसा होती है, लेकिन पुरुषों को विरुद्ध भी घरेलू हिंसा होने लगी, इस पे भी विचार करना चाहिए। निश्चित रूप से परिदृश्य नया सामने आया है, बहुत सारी ऐसी घटनाएं हो रही हैं जिसमें पुरुष भी प्रताड़ित हो रहे हैं। तो आज हम लोग मैडम को सुनेंगे। बहुत सारी, क्योंकि मैडम मुंबई महानगर से जुड़ी हुई है। हम लोग बनारस से, उत्तर प्रदेश का पूर्वांचल का एक प्राचीन नगर है। वहां और यहाँ की वस्तुस्थिति न्यायिक, सामाजिक या राजनीतिक बहुत अलग है। तो ये हम लोग का सौभाग्य है कि हम लोग आज मैडम को सुनेंगे और निश्चित रूप से उससे लाभान्वित होंगे। भविष्य में हम लोग भी आपसे अकादमिक रूप से जुड़ेंगे और भविष्य में आपका भी हम लोग सहयोग लेंगे, अपने विश्वविद्यालय में आपको आमंत्रित करेंगे। मैं पुनः एक बार बंबई के कुछ बातों को बताना चाहूंगा। पहले दिन मेरे वक्तव्य में किसी कारण से, तकनीक कारण से वो बात मैं नहीं कर पाया था। आज मौका है, कल मौका मैडम देगी कि नहीं। आज इसमें मैं कहना चाहता हूँ कि बंबई से अगर मैं जुड़ा तो उसका बहुत बड़ा श्रेय जाकर अरुण शर्मा को जाता है। वो हमारे बनारस से हैं, हमारे विश्वविद्यालय से जुड़ी हुई है। वहां से हमारा जुड़ाव निश्चित रूप से इनके कारण से हुआ। आज बंबई में बहुत सारे लोग, हमारे विभाग, हम सभी लोग को जानते हैं, हम लोग के लिए बड़ी उपलब्धि है। उनके अकादमिक जो भी कार्य है उससे हम लोग लाभान्वित होते हैं, हमको उससे बहुत फायदा होता है। इसके लिए हम मुंबई के विश्वविद्यालय, महाविद्यालय से जुड़े सभी लोगों का हम आभार व्यक्त करते हैं। और हम ये अपेक्षा करते हैं कि भविष्य में भी इस तरह के कार्यक्रमों से हम लोग को जोड़ें और साथ कार्यक्रम कराने से बहुत सी बातें को हम लोग को सीखने को मिलती है। मैं अपनी बात अब यहाँ समाप्त करूंगा क्योंकि कार्यक्रम को आगे बढ़ाना है। संचालक महोदय को आगे बहुत सारे काम करने हैं। सबका धन्यवाद, सबका स्वागत, सबका आभार। धन्यवाद।
Thank you, Honorable Dr. Ranjan Kumar Sir, Head and Dean, Department of Law, Mahatma Gandhi Kashi Vidyapith, Varanasi, for proposing a welcome address. Now, may I kindly request Honorable Dr. Mrs. Sheetla Shrikant Gawan Madam, Principal, Bhagubai Changu Thakur College of Law, New Panvel, Raigad, to introduce Honorable Chief Guest and to say a few words.
Namaskar and very good morning. I would like to begin today's session with one Sanskrit shlok. Na chauryaharyam, na cha rajyaharyam, na bhatrubhajyam, na cha bharakari vyate, krute vardat eva nityam, ityadhanam sarvadhana pradhanam. It cannot be stolen by thieves, cannot be taken away by the king, cannot be divided among brothers, and does not cause a load. If spent, it always multiplies. The wealth of knowledge is the greatest among all the wealth, among all wealth. So, with this Sanskrit shlok, I heartily welcome our today's honorable guest speaker, Ms. Mrunalini Deshmukh Madam, Advocate, High Court, Bombay, Honorable Professor Dr. Shri Varadi Madam, Head of Department of Law, University of Mumbai, Honorable Professor Dr. Ranjan Kumar Sir, Head and Dean, Department of Law, Mahatma Gandhi Kashi Vidyapith, Varanasi, Honorable Advocate Sudeep Pasbola Sir, Vice President, Bar Council of Maharashtra and Goa, all respected principals, professors, teaching staff, and my dear students and friends. A very warm welcome to all of you. Dear all, really, this webinar series, Law at Your Doorstep, is a feast of knowledge. Every day we are listening to great luminaries who are imparting their legal knowledge, sharing their experiences and inspirational thoughts. It is our immense pleasure to get an opportunity to organize this webinar in collaboration with Law Department, University of Mumbai and Mahatma Gandhi Kashi Vidyapith, Varanasi. We are honored this evening by the presence of Honorable Guest Speaker Ms. Mrunalini Deshmukh Madam, Advocate, High Court, Bombay. It is my great pleasure to introduce Honorable Guest Speaker, a celebrity lawyer, Ms. Mrunalini Deshmukh Madam, Advocate, High Court, Bombay. Ms. Mrunalini Madam belongs to family of jurists, descendant of great freedom fighter Tatya Tope, and her father, late Dr. Krishna Tope, was an authority on constitutional law, a noted educationist, a biographer, a lawyer, and a teacher, who later rose to become the Vice Chancellor of Mumbai University. Akin to the legacy of her father, she too has achieved greater heights with an impeccable professional record, which warranted her to be a TED Talk speaker. Advocate Ms. Mrunalini Madam has an expertise in the field of family law with a professional career spanning over 2 decades. Ms. Mrunalini Madam is an alumni of prestigious institutes like St. J.B.S.P, Mumbai and Government Law College, Mumbai. She has completed her LLM through University of Mumbai in commercial law as well as matrimonial laws. She has been a professor of constitutional law like her father, and she has been a visiting faculty at the Department of Law, University of Mumbai for post-graduation. She is a firm believer of gender justice and a staunch gender equality activist. She is also involved with the NGO called Sampark, which rehabilitates children of sex workers and HIV positive parents. She has really addressed an international conference on wealth planning for global Indian families in Dubai, UAE. She strongly believes in the institution of marriage and the joint family setup, which has reflected in her personal life. Her book, Breaking Up, Your Guide to Getting Divorced, answers every question you might have on the subject. Advocate Mrunalini Deshmukh is one of India's top divorce lawyers. She has handled some of the most high profile cases in the country. Using her 2 decades of experience and expertise, she has put together this book on understanding divorce laws. Advocate Mrunalini Deshmukh Madam has been a party to cross border legal cases relating to marriage, validity of foreign court orders, applicability of the Indian laws of marriage and their effects, for which she has been invited to give legal opinion in foreign courts and has also been examined as an expert witness. To name a few, she has been a party to a proceeding before Boston Court, USA, New York Court, USA, Sydney Court, Australia. She has also given expert legal opinion in the courts in Dubai, UAE. She has to her credit several conferences and events where she has addressed national and international audience on various subjects of her expertise. And today we have this great opportunity to enlighten ourselves from this extraordinary luminary, and it is really an immense matter of pride to introduce to you and welcome Honorable Advocate Ms. Mrunalini Deshmukh. But more than this accolade, she is also a great badminton player, a friend, guide, and philosopher, and a role model to all of us, and a very nice human being who has helped large number of people from all walks of life. Thank you so much, madam, for accepting our invitation. Now I call upon Honorable Guest Speaker Ms. Mrunalini Deshmukh Madam, Advocate High Court Bombay, to enlighten our participants and students with her knowledge and inspirational thoughts in this Legal Aid Awareness 4 days webinar series, Law at Your Doorstep. Thank you so much.
Good evening, everyone. It's indeed a great pleasure and honor to be here amongst really all erudite and knowledgeable people like the principal of the BCT College, Professor Ranjan Kumar from the Banaras University, and of course my own Department of Law, Bombay University. When I was invited for this to address this webinar, I was a little excited more, not only because I had to address a great audience like you all, but also because it felt like homecoming. I have done my master's in law from the University Department of Law, Bombay University. And I have also had the privilege and the honor of being a visiting professor there at the Bombay University. So I think it's homecoming for me, and that also gives me a great pleasure and an added zest to address all of you. Professor Ranjan Kumar from the Banaras Hindu University, I have had a great reverence for the learned and the knowledgeable from from the city of Varanasi, which has been the seat of knowledge in our ancient books and in our ancient history, as we have seen. So I think it's a great collaborative effort by all of you concerned to bring about this legal awareness, or the legal aid at your doorstep, as you call it, and which is because, as we all know, knowledge is power, and if you have the knowledge, then you are more powerful. It's not the money, it's not the wealth, it's not the political power that gives you the real strength, but it is the knowledge of power. I'm myself an eternal student of law, and I learn and absorb from all of you also over here, and I look forward to how would I say, a healthy interactive session with all the participants, which I believe from my screen, I see there are around 203, 204 of you. So thank you so much for giving me this opportunity. When I was approached and I was told that I need to speak on something which is, in fact, this morning I was told that I have to speak a little bit about the family court and its functioning. So I will come to that, but just as a part of it. But the main subject that I have been asked to speak is about domestic violence and act, and whether that has been a step towards women empowerment. So I think it's a very how do I say, it's a very sensitive issue. It's a very sort of contemporary issue, and it's an issue which you and I see as laypersons everywhere happening. Now, coming to this, the most important thing is that this act, that is the Protection of Women from the Domestic Violence Act of 2005, was enacted as late as 2005. Does it mean that there was no domestic violence prior to that? Does that mean that there was no need for any legislation to that effect? And what was it that really prompted the makers of, or the framers of or the legislators to frame such an act which was there? Before I get into the detailing of it, the statement of objects and reasons, and why this act has been enacted, I think the basis of this act, from my own studies and from the other studies that I have read also, this act was important because there was violence which was perpetrated in the society. And violence was not only perpetrated in the society at large, but there was violence on the domestic front also, within the four walls of the house, which went unnoticed, which went unchallenged, which was just brushed under the carpet without any effective remedies being taken. Now, according to me, the reason for this violence, if I do a little bit of sociological studies and a little understanding of it, arises out of these three or four parameters. Number one is the patriarchal mindset of the society. So it has always been a patriarchal society, a male-dominated society, and it is the man who is more powerful as compared to the... Sorry? It's only a man who is more powerful, is powerful than the woman, and he had every right to deal with the woman the way he wanted. It also came from the basis of the superiority of the man over the woman. It also came from the fact that women in the earlier days, and I'm not talking about in the recent past, but of course much earlier, were treated as a chattel, were treated as some kind of a property which could be dealt with the manner that they wanted. And along with that, that gave a different kind of a power equation, or for the man to deal with the woman, and he wanted to control the woman, and violence was one of the ways of tackling. As far as the women were concerned, there was lack of education, there was illiteracy, poverty, ignorance, financial dependency on the man, and lack of finances to stand on her own feet, which made her suffer all these things. So where there is inequality, and inequality in every sense of the word in letter and spirit, this is where the essence of the law has to be done. Now let us understand, and let's go step back and let us see what was the constitution which was framed way back in 1950. What does it talk about? Article 14, Article 15, and Article 21. These are the only three articles I'm going to deal with. Article 14 talks about equality. Article 15 talks about no discrimination on the grounds of religion, sex, etc. And Article 21 talks about right to life, right to lead life with dignity. Now, the question that arose is that if the Constitution of India way back had given us these three fundamental rights, Article 14, 15, and 21, which talked about equality, then why is it that there is a need to have a special enactment for the women? Because the Constitution is very clear. We are all treated equal in the eyes of law. In fact, you'll be surprised to find in Article 15, subclause 3, it says that nothing shall prevent the state from making special laws for the women and children. Now, how do you explain this? When you have 14, 15, which talks about equality, why should the same section have something which says that nothing shall prevent the state from making special laws for women and children? The reason behind this is that this was the basic social cultural structure of the Indian society, in which to achieve equality, the upliftment and the empowerment of the so-called weaker sex then had to be achieved. Because there can be equality only between the two equals. Can you have equality between the unequals? The answer is no. So if you have to make 14 and 15 and even 21 article to a large extent not only valid, but I would say effective, then you need to raise the status of the woman to be made equal to that of a man, to be able to really effectively deal with it in on the platform of equality. Now, to empower the women or to raise them or to uplift them from that society, there were a lot of social reform, there was social norm that was going on. But the most important thing that led to the empowerment, or I would say the upliftment to that to a large extent, besides other factors like education, having one's own financial wealth, etc., was the fact that the protection of the woman, the safety of the woman, which was at stake at one point of time, was taken care of, and she was empowered with a special legislation to enable her to not only protect herself and from the violence that was perpetrated on her as a woman, but to be effectively equal to a man to be able to achieve certain things which are there. So if you go back to the history of the protection of women from the Domestic Violence Act, the history is the social, historical, cultural structure of the society which made it. I would say it's been a little too late, not little too late, quite late for the legislation to think about this law. Because if you see overseas and if you see in most of these Western countries, the law has been in existence for a long period of time. It is only in 2005 that we realized that we need to have a special enactment, which is protection of women from the domestic violence, that a law was enacted, and the rest is history as we call it. So having said this is the background for why the Protection of the Women from Domestic Violence Act was made. And as you are seeing, that this law is made only for the women, for the protection of the women, and by, I mean, the respondents on the other side could be the men. Now let's go to the statement of objects and reasons. As you are all, as some of us are students of law here, and of course some of us are professors and legal authorities. The basis of the act comes in the statement of objects and reasons, as you may have studied. Now the statement of object and reasons, it says that this is an act to provide for more effective protection of the rights. Every word is so important. Effective protection of the rights of the women, which are guaranteed under the Constitution, which I just read out to you, which I just explained to you in Article 14, 15, and 21. Such women who are victims of any violence of any kind occurring within the family and for matters connected therewith or incidental to. So this is an enactment which was protection of the victims of violence happening within the family. As I said, within the four walls of the home, the violence that was being perpetrated on the women, this is an act which has been framed to deal with it in an effective manner. The interesting thing about this act, and I would say interesting and a progressive thing about this act, is that it talks about any woman. Now, pausing here for a moment, if most of us know that the IPC was amended, and after the amendment was made in the IPC, Section 498A was introduced. Section 498A typically talks about cruelty to women from her husband-in-laws, etc., and what are the penal repercussions, what are the consequences, etc. I'm not getting into that because that's not the scope of my discussion today. Now, when this amendment to IPC was made, when cruelty to the wife was made, this was only with concerning the woman who was subjected to harassment, either for dowry or for any of the things, or mocking her, humiliating her, or making fun of her, causing her pressure on her, causing stress to her, etc., came under the clause of cruelty, including physical violence. Then there was a need to have a special enactment, which is the 2005 DV Act, as we very popularly call it, when there was already a provision made over there. So the difference between these two, if I may explain to you, is that the DV Act, the 498A, Section 498A comes under the IPC, so it comes under the criminal law. And though this is the protection of women from the Domestic Violence Act, it can be filed before a magistrate, or it could be filed before a civil court, which I'll come to a little later, and has to be dealt with. This is basically a civil procedure. So there is a civil enactment for the protection of women from violence, and there is a penal enactment, which is section 498A, which is also protection of women from violence, and violence in different forms, which is there. Because if you see that in this case, if there are any kind of orders, any kind of violation which is there, the compensation is in terms of monetary compensation or protection or residence, or in case of children custody, or in case of women who are without any money maintenance. So these are the provisions which are in, which I will come to a little later, which are covered under this enactment, which is the DV Act. I'm going to call it DV Act for the for easy reference. And as a result of which, this enactment becomes relevant, where a woman may not want to penalize the man, be it the father who is torturing the daughter, the husband who's torturing the wife, the in-laws who are torturing the daughter-in-law, and so on and so forth. But where her dignity, her protection, and all the rights enshrined under the Act are granted to her, to enable her to lead a life of dignity, and to enable her to lead a life of, how do I say, a complete life without being subjected to any kind of violence on her. Now, when we talk about violence, what does violence mean? Now, there are a few terminologies that I would like you to first appreciate. I know most of you are practicing lawyers. I'm also aware of the fact that most of you have been using this enactment in favor of your clients and have been using this. But what is absolutely important is that certain terminologies are very important for us to understand. The person here, that is a woman who is it, is called the aggrieved person. So aggrieved person is defined in section 2, which says it means any woman. And I'm going to read every word very slowly and gradually, because we need to understand what the legislation has entailed. Any woman who is or has been, who is, present tense, has been, past tense, in a domestic relationship with the respondent, and who alleges to have been subjected to any act of domestic violence. So when you say any woman, it doesn't mean only the wife. Now, if you go to section 498A, it means the wife has been subjected either by her husband or the daughter-in-law, but it means a married woman. Whilst here, it says any woman, which means whether she is married to a man legally, or she is in a relationship which is akin to marriage, which is what they call it, a live-in relationship. So today, not today, when the Act was enacted for the first time, the rights, the importance, and the recognition of a live-in relationship, basically with reference to the woman and her protection of her legal rights, was recognized by the legislation, which otherwise was treated as, she was treated as a concubine, she was treated as a paramour, she was treated as a girlfriend, whatever you may call it, and she had no rights. For example, in earlier times, I remember, because I started my practice a couple of decades, a little less than that, and when I was practicing, there was a lot of cases which came where a man would get married to, a man was married and probably he had deserted his wife, or he was even living with the wife and got into a relationship with a woman. To convince her, to give her the security, he would say, okay, let's get married. They would undergo ceremonies. You all know that unless the first marriage is dissolved, the second marriage is no marriage in the eyes of law, after the 1955 enactment of the Hindu Marriage Act and other enactments after the codification that has taken place. And then suppose something goes wrong between the husband and the second wife, we will just call her second wife for the sake of argument. So there is no such concept of a second wife in law when the first wife is living and the relationship is valid. The second wife, he would desert her, and then she would go to a court of law. Now, when she went to a court of law, and she would say, I am the wife of this man, Mr. So-and-so. He has deserted me. he's not paying maintenance to me, or he's committing offense of violence, etc. on me. Kindly grant me some monetary relief. The courts would then say, the husband would then be sent summons, and the husband would come and say, but how can she be my wife? I'm already married. I have 2 children from my marriage. And conveniently, the first wife would come because they wanted to save the money. And the lady who was the petitioner or the aggrieved person was left to say that, okay, sorry, but your status is not that of a wife. You have been living with a man who was a married man. And even if you may have undergone any ceremonies in a temple or at home or whatever the case may be, you are not a wife. And if you are not a wife, you do not get anything. So then those women were compromised and they were left in a lurch, and they just didn't know what was the remedy available to them. So these are the practical problems that legislation with interaction with the various NGOs, women organizations, and other people understood that these are the problems that people are facing in our society, in the Indian society. And the woman is at the receiving end, and because she does not have a status, there is no law to protect her. That is why this petition has specifically mentioned aggrieved person means any woman who is in a domestic relationship. So you could be in a domestic relationship, and if you are aggrieved, you can come to the court, or you may have been in the domestic relationship and you may have come now today, you may have come and asked for certain reliefs which are there. And lastly, and more importantly, it says that if she is subjected to any domestic violence. Now, please understand one thing, that when we talk about domestic violence, the first thing when you talk about violence comes to our mind is a physical violence. A man beating up a woman, whether she's wife, girlfriend, etc. So what does domestic violence mean? Has also been explained and defined in a very exhaustive and lucid manner by the legislation in Section 3 of the Act, which defines what is domestic violence. Domestic violence, Section 3 says, for the purposes of this Act, omission or commission or conduct of the respondent shall constitute domestic violence. And please bear with me that I'm going to read a little slowly. In case it harms, injures, endangers the health, the safety, the life, limb, or well-being, whether mental or physical, of the aggrieved person, comma, or tends to do so, and includes, so it's such an exhaustive thing, includes causing physical abuse, sexual abuse, verbal abuse, emotional abuse, and economic abuse. So the definition of domestic violence is not only limited to physical violence perpetrated on the lady, on the woman, as the case may be, but this is the way it has been. So it is talking about the physical health or well-being and safety, the mental health and mental well-being and safety. So you may not beat your wife, example, you may not beat your wife physically, but you may make allegations against her about her character. You may make allegations about, even running her down. You can't cook, you look ugly, you can't cook, you can't do this, you can't do that, humiliating, insulting her in front of the people, whether they're friends, relatives, social things which are there, and taunting her. This is a greater abuse that a woman can tolerate. And this has also been captured by the legislation in the definition of domestic violence. So when we talk about it, now they have defined what is physical abuse. Physical abuse means any act or conduct which is of such a nature as to cause bodily pain, harm, danger to life, limb, and includes assault, criminal intimidation, and criminal force. Sexual abuse, and I'm going to deal with all of them very effectively, because for the students of law or the young practitioners who want to take this, have to first understand these concepts before they are able to argue before the courts what it really means. Because there's no point, if I may share my experience, pasting a section and putting that in your pleadings. When you put something in your pleadings, you need to understand what it means, What are the repercussions? What does the law entail? What is the definition, if at all, given in the definition section? And then you would be able to apply. As we all know, in pleadings, you have to state the facts. And then you may come to your own conclusion and what it amounts to. So, physical abuse, I have told you. Sexual abuse means any conduct of sexual nature that abuses, humiliates, degrades, or violates the dignity of a human. So, again, as I said, the husband may, and I'm just taking a random example, a husband may not beat the woman. The husband may not probably talk ill about the woman, but the husband is a demon when he is in bed, and he becomes aggressive, aggressive in the sense of demonic aggression, very aggressive like a demon. He causes physical body harm to her. He also causes pain to her. He expects her to indulge into unnatural sex against her wishes and desire because that gives him satisfaction. Or he degrades her, and he's not he treats her in a very, how could I put it, in a very inhuman manner while doing this. This also amounts to sexual abuse. Now, since we are on this subject, an issue which most of you may have read, that whether marital rape is something that the legislation should consider to be made a part of a criminal offense under the IPC, and whether that also constitutes cruelty of a grave section. So there are two sections of the society, and the opinion is divided. One section, which is the conservative section, believes that marriage means a license to have sexual relationship with the partner, a lady to a man and a man to a lady. So how can there be rape? And the second section of the society feels that anything done in a relationship, even if it's a legal relationship of husband and wife, where sex is the basis, or the sexual relationship is the basis or the edifice on which the relationship is there, if there is no consent, and if there is force, and if there is aggression, which is against the wish and harming the safety and the well-being of the wife, that amounts to rape, even if it is sex within marriage. Now, please understand that it's a very touchy subject. But having said this, there are countries like UK and some other European countries where marital rape is an offense and is dealt by the courts in a manner like any other offense which is there. But I'm not going to get into the controversy here right now, because this is a forum for people like us who are students of law, who want to learn, and who, as practitioners of law, who learn from our experiences, from our clients and what we see in court, would like to suggest and submit to the legislation or to the lawmakers as to what would be something which is practical and viable in a given set of circumstances. The third one is verbal and emotional abuse. So it includes insults, ridicule, humiliation, name calling, especially regarding to not having a child or not having a male child. So, running her down, treating her like an sex machine, insulting her, humiliating her if she's not earning, or if she is not capable of doing some certain things which are there. Or in some extreme cases, if a woman has a physiological problem that she's unable to conceive, to degrade her and humiliate her, that she is unable to conceive. So this all amounts to emotional abuse. And also, what includes emotional abuse is repeated threats to cause physical pain to any person whom the aggrieved person is interested in. Now, what does that mean? I'm very fond of my mother, and my mother is living with me. If the husband comes and he says that you better do what I tell you, otherwise I'm going to torture your mother. I, as a daughter, do not want my mother to be tortured, or any other person who's staying in the house to be tortured. Out of the fear that the threat to harm that person is there, I subject myself to all this violence. Now, this can also be stopped by the law. So you see how wide the scope of this enactment is, and how the law has considered even small things or minute things that happens in some families, and they have covered those aspects also whilst dealing with it. And the last one is the economic abuse. Now, in this emotional abuse, which is what is not typically mentioned here, but which we see in our practice, is that if a man is having an affair with a woman, okay, and as a result of which this wife, her dignity, her self-respect is compromised, and she feels, obviously no woman would like her husband to be in a relationship with the other person. So the fact that her husband is in a relationship with another person, or that he goes to prostitutes for his sexual gratification, or he has escorts, or all those things which are there, this is also an emotional abuse which is perpetrated on the woman, and she has every right to go. Lastly, is what is known as economic abuse. Economic abuse means deprivation of any economic or financial resources to which the aggrieved person is entitled under any law or custom, whether payable under the court or otherwise, which the aggrieved person requires out of necessity. But it's not limited to household necessities for her and the children, stridhan, property jointly owned, etc., etc. Now, deprivation of the economic and financial resources. This typically happens in two ways. I'm talking about in a practical way in courts, which we see. Number one, in cases where a woman is a homemaker and she is supposed to run the house from the money that the husband gives her, look after the children, look after the house, and look after all the other essential things which are there. And depriving her of that with a view to cause her harassment, with a view to cause her grief, with a view to dominate over her, control over her, and show her that, listen, I am the one who's providing all your, if I stop your money purse, if I stop the financial thing, you will be hungry and you will be lying on the streets and your children will be doing this kind of sadistic pleasures which certain men get. Now, this kind of is also a great abuse for the woman, because if she is financially dependent on the husband, then it, and the husband not providing her, is also amounting to economic abuse. Now, in this relationship, if you remember, in this context, if you remember, I think a year back, if I'm not mistaken, a year back, there was a matter which reached the Supreme Court. And the issue was whether the homemakers should also be paid for all the jobs that they do selflessly for the family. Some of us do cooking, cleaning, swabbing, some of us do something much more. But if we are homemakers, that is housewives, should we be paid for it? And there was a divergent views on it. Some of the liberal activist women said that yes, they should be paid for it. My view on this was there that if you don't want to, if you, I would not want to be paid for, if I cooked a meal, paid for it, or if I swept the floor, to be paid for some, if I was a homemaker. But if you have to give the dignity to the woman as a homemaker who is, the very word says, she's making your home. I mean, what other things do you want? She's the one, because of you, she's making a small little place your home, a warm nest for you and the kids to come back and to be at one after you finish your day's work. So if, in my view, and what I had given my view was that you do not need to pay her for this because she does it selflessly, number one. And number two, you cannot equate it, because she's not a cook who cooks for you at a price that you pay a salary to a person who's outside. She's someone who cooks for the family with a lot of love and affection, keeping in mind, what do my children want, what does my husband want, what do my in-laws want, and do this. Can you ever compensate that way? No, you can't put a price. But I said at the same time, these women should not be left to the vagaries of nature or to the moods of the husband and be dependent on them for the financial thing. So if you're not able to give such kind of women, and which you should not give them money for the work that they do, the homemakers, but you could make investments in their names or in the joint names, so that there is a respectable way of acknowledging the fact that yes, you've been a homemaker, yes, you've not been an earning member, but your contribution to the running of the house, looking after the children, the old parents, etc., is absolutely immeasurable. And this is a small way of having investments, etc., in her name, to give her that dignity and to give her that financial security. Sorry, I'm just going away from the topic, but I thought it's a socially and legally relevant issue, and so I thought I must talk to you about it. So this is what economic abuse means. It also means alienation of assets, movable, immovable, shares, securities, bonds, etc. Sometimes these things are done with a view to deprive the woman of her rights into it. Unfortunately, under the Indian laws, as we speak of alimony maintenance, etc., we do not have a concept what is known as equitable and proportionate distribution of the marital assets. Now, what do I mean when I say all these things? If you see in most of the Western countries, you see in the US, different states in the US, you see it in UK, Europe, etc. Whatever the assets are sort of earned by the couple, whether one person is earning or two persons are earning or whatever, all those assets are pooled in together. And in the event of a divorce, those marital assets, that is, assets acquired post the marriage, are equitably distributed in some of the states in the US and in some other countries also. So that a woman is given a right on the asset that has been earned. In India, as we speak, we do not have the concept of the joint and equitable proportionate distribution of the assets as one of the essentials under the alimony. We just have an alimony concept and a right of residence as far as the wife is concerned. In certain enactments, it's gender neutral. So, having said this, the it is very important in a way to make this kind of how do I put it, dignity to her by giving her some share in the assets is what the discussion is also about. So sometimes in cases of domestic violence, any property which is owned by the husband says, I'm going to sell off my property. So there's a house, say, which is worth 2 or 3 crores. It stands in the name of the husband. Yes, bought by the husband. In fact, just this morning I had a case which came to me. 45 years of marriage. The lady must be in her late 60s. Got married early, and the husband was also in his early 70s. Some disputes have been happening, and then they have an apartment in Bombay. And he tells her that, listen, I'm going to sell off everything which is there. You better come with me to some place which is the native place. Now, all their life they've lived in Bombay. The lady has lived here, her daughters who are married are living here. And he's threatened her that, listen, I'm going to sell my house and you better come and stay with me wherever I'm staying, and you have no right to decide where you want to stay. Now, does he have a right to sell the house which stands in his name? In law, yes. Whatever belongs to me, I can deal with the property the way I want. But is it correct in a family relationship, in a matrimonial matter, where you deprive the wife of her rights to stay in the house just because she's not an earning member and just because she's not contributed? Now, for such women, whether they are into a short period of marriage or a long period of marriage, the law has come to their rescue. Where if you feel threatened by this, and there's no divorce, there's nothing which is there. But if you feel threatened by the fact that to humiliate you or to belittle your dignity, this is what the husband is doing, then under such circumstances, the courts will come to the rescue of this woman, injunct the husband, or as the case may be, from selling, disposing, creating third-party rights, and dispossessing the wife pending the hearing and final disposal of this, proceedings which are there. So that is the other kind of issues that are also dealt with. So in fact, in my opinion, what the enactment says, and there are a variety of cases which happen, and each case is different. I mean, it cannot be identical. It cannot just come under it. Now, if you go to the different sections of this things which are there, number one and most important is that there are protection orders. What are the protection orders? Which comes under section 18. It says that the magistrate may, after giving the aggrieved person and the respondent an opportunity of being heard and being satisfied that domestic violence has taken place or is likely to take place, a protection order. What is a protection order in favor of the woman? Of committing, or in favor of the woman and against the man, that the man cannot commit any act of domestic violence, by aid or abetting the domestic violence, entering the place of employment of the aggrieved person. Pausing here for a moment. A husband, in many cases that I have dealt with, the wife is working and probably the husband is not working, or the husband is very suspicious about it, and there could be various factors, or he's got some psychological issues, or he's been instigated by someone. He goes to the workplace and creates a scene over there. Now, as a lady who is working at a place, whether she's a lawyer, she's a doctor, she is working in an IT, she's working in any company, I mean, to have the publicly being sort of abused and sort of mocked at by your own husband, where nobody can do anything because he's not an outsider. If there was an outsider, the security would stop him at the gate and do that. But he is the spouse of the person who is an employee of the company, and they create this scene only to cause embarrassment to the woman. So if this kind of fear is also there in the mind of the wife, then such kind of orders injuncting the person from entering the workplace is also granted. Also, attempting to communicate or create some kind of communication which is likely to turn abusive, likely to be derogatory, and likely to demean her or to ridicule her, then the courts may even say. Now, today, as we all know, the easiest way is to send WhatsApp. So, suppose if a husband or a man who's in a domestic relationship sends abusive messages to her from his phone to the other phone, or sends emails to her, sends obscene pictures or obscene articles, etc., to her, or which is derogatory and which is demeaning her, including some of the cases as we have seen. I don't know whether you're aware, sending the nude photographs of the woman, if there are any, during their so-called good days which are there. This all amounts to domestic violence. These protection orders can be given. I had dealt with a case I would like to share with you. It was a very famous case, but I will not get into the names because I do not talk about them. Yeah, it was about a celebrity. The husband and wife were married, and they were married, and they had gone on a honeymoon to one of those Macau or one of those places. But during their intimate moments, so they'd gone on a honeymoon, and during their intimate moments, for whatever reason that they felt, they had taken certain pictures of their intimacy, just as memories, because they're husband and wife, and they're so with things. What the husband did was later, because he wanted, then after marriage, this went on for some time. Then the wife came from a wealthy background, so she bought an apartment, and they were all staying in the apartment. And disputes arose between the husband and the wife. The husband started insisting that this apartment which stand in your name, you please transfer it in my name, okay? Because I can't live with you. You have lots of money. You can do that. So she said, why should I do it? This is my money, and why would I do that? Because she refused to do that, he threatened her that he would put a video on the internet and expose her. And what was that video? And I'm saying this because I have seen that video in a court of law when I was asked by the magistrate to do it as her lawyer. That video was of their intimate scenes, which was edited by him very smartly, and which was absolutely vulgar, to say the least. And vulgar, I'm saying in the sense that, of course, it was during an intimate moment of the husband and wife. But if a third person saw it, was very obscene, if I may use that word. And he threatened her that if she did not transfer the apartments in his name, he will put it on the internet and he will humiliate her. It will go viral, and all her name, her dignity. She came from a big family, a big home. All this will be, they will all be exposed. Now, please imagine the plight of such a woman. What will happen if such a woman is threatened with such a thing? Is he hitting her? Is he beating her? Is he doing anything? But can there be a bigger violence than the blackmail that was going on, which was perpetrated by him? So for such kind of things also, a lady can approach the court and restrain the husband from doing any of these acts. Restrain the husband from communicating with her, communicating with her about anything which is obscene or which is unsavory. And this can be done, as it says, by electronic or telephonic or a written communication. Then another violence which they talk about is alienating any assets, operating bank lockers, bank accounts jointly by the aggrieved person. So it could be a situation where the locker stands in the name of the husband and the wife, which is a joint locker. The wife has kept her jewelry. Now the husband is demanding the jewelry from her, and she says, "No, this is my jewelry, and this is kept for me, for my children, or whatever the purpose that may be there. You cannot take it." And she refuses to give him, and she fears that he may misuse and operate the locker and do any of these things because it's in the joint names. Then, under such circumstances, injuncting him from operating the bank locker, so that the jewelry is not taken away or it is not misused by the husband, can also be given. So these are the protection orders which are given. Now, these are the different varieties and different categories. And as you would realize, that these are some things that we as practicing lawyers, and I'm sure most of you are also practicing lawyers who deal with it, see it in our day-to-day life in the cases that we conduct. Either we are for one person or the other person. And as they say, truth is stranger than fiction. Really, you see that in the law courts when we see the number of cases and the variety of cases that come in this situation. So in this, the if such kind of cases go before the magistrate, then the magistrate will have to hear the aggrieved person. He will have to give an opportunity to the respondent. The respondent will be heard, and only after such hearing, the courts will pass appropriate order, which again is for the protection of the women. The next clause that we are talking about are the residence orders. Now, for a woman who gets married and who comes, or even in a live-in relationship, when she comes in and she stays in a marriage, or she stays with a man, sorry, and in that case, what she gets is there is a roof over her head. Now, what happens if that roof over her head is taken away, or she's threatened that it will be removed, or she's dispossessed, and she is thrown on the street? The example which I gave you earlier about a lady who was in her late 60s and the husband which was there. So can the courts pass any residence orders protecting the residence of the wife or a person who's in a living relationship to ensure that she has that safety, that security, and she's not thrown on the streets because she has no other, alternative funds or means of income to find any kind of shelter for herself. So the residence orders provision is also there under section 19, and I'll just read out to you. It means while disposing of an application under subsection 1, the magistrate may, on being satisfied that the domestic violence has taken place, may pass a resident order restraining the respondent from dispossessing in any other manner, disturbing the possession of the aggrieved person from the shared household. Now, in the definitions, I forgot to, when I started my lecture, forgot to tell you what is a shared household. Now, when we talk about this, the important definition that we need to understand is what is meant by a shared household. And the word shared household has been defined in section 2 of the Act, where they are talking about a shared household. It is section 2, subclause S. Let me just read out to you. A shared household means a household where the person aggrieved lives or at any stage has lived in a domestic relationship, either singly or along with the respondent. And it also includes a household, whether owned, tenanted, either jointly by the aggrieved person and the respondent or tenanted by either of them, in respect of which either the aggrieved person or the respondent or both jointly or singly have any right, title, interest or equity, and include such a household which may belong to the joint family of which the respondent is a member, irrespective of whether the respondent or the aggrieved person has any right, title, or interest in the same. Now, let me just explain to you what are the various nuances as far as the shared household is concerned. Typically, a shared household is something what, if for a married woman, is something which is similar to a matrimonial home. Now, you will be surprised to know that the concept of matrimonial home is not defined in any of the enactments that we have. Now, what is a matrimonial home and what constitutes matrimonial home? To refer to what means a matrimonial home, you have to go to the English law, which is the Matrimonial Causes Act 1857, in which they have defined what is a matrimonial home. But the difference that you find in, say, let us say, the English law, on which our Indian law is based, and the Indian law is the social structural setup of our society. Now, under the Matrimonial Causes Act, the matrimonial home is a home where the husband and wife live together post the marriage, correct? Mostly 80-90% or even more than that, couples overseas, they rent a home or own a home, and it's only the couple who lives, and then later on the children are born, then they start living. But what happens in an Indian scenario? In an Indian scenario, when a arranged marriage or love marriage, which is there, we still have children who are of a marriageable age and post-marriage also living with their parents. Number one, there could be one home which is owned by the parents. The son grows up, the son gets married, the daughter-in-law is brought into the house. Now, when she is brought into the house, for her that is a matrimonial home because she's staying there with her husband. Now, if tomorrow there is a dispute between them and the husband threatens her to throw her out, or the in-laws threaten her to throw her out, can the defense be taken by the husband and the in-laws that this is the in-laws' house and she has no right to stay in this house because my son cannot get along with her? And this is not a matrimonial home because it is not bought by the husband. At the same time, the law says that if the husband has any right, title, interest in terms of the word as you understand, or it is bought from the funds of a joint family or ancestral home of which he is a member, like a HUF or a co-parcel, then in such cases, the wife has a right to stay in the house. Now, there are two situations. One, the in-laws supporting the husband but not supporting the daughter-in-law would create a situation where they want the daughter-in-law to get out. But if the husband is residing there, then as a daughter-in-law, you can say, my husband is residing in that house. If he is residing, I have a right to reside in that house. So some of the cases, as we see in the court, what happens is that the in-laws have a mock throwing away of or ousting the couple. They say, you husband, you wife, you are fighting, you are my son, you are my daughter-in-law, you get out of my house. You guys have no rights over my house. And then the husband rents an apartment and the court says, listen, your husband has rented an apartment. Don't expect to stay in that big house which you were staying because it doesn't belong to you, it belongs to the parents. You have to stay with your husband wherever the husband is there. So there are two divided sort of opinions on what constitutes a matrimonial home. Is it a home in which the husband has a right, title, interest, whether as an owner or as a tenant or whatever the case may be, or where he is a joint family ancestral property, or whether a home where the wife has lived post her marriage for say, substantial period of time, whether that amounts to the matrimonial home. So there was a case which came up right up to Supreme Court, which was S.R. Batra versus Taruna Batra, 2007 3 SCC 169, in which the Honorable Supreme Court judges, Justice Kaju and Justice Sinha held that if a home belongs or if a place belongs to the in-laws, bought by the in-laws from their funds or what if they have sort of individually inherited, not from that part, but it's the first succession of the first degree, then under such circumstances neither the son nor the wife can stake any claim by saying it is a matrimonial home, which is in a way true, because what happens is what we see in certain cases is that there are disputes between the husband and the wife, and for no fault of the in-laws, they have to bear the brunt and they have to suffer this, though it is their own house, they've worked hard for the house, they've lived as a couple in this, that is the father and the mother have lived as a couple over here, the children were born, they've raised it, and in their own house they're asked to say, okay, you please keep this daughter-in-law in the house because she's creating a hell, but you have to suffer because she is married to your son. Now, is it fair on the senior citizens and is it fair on these people who have nothing to do with the dispute, but who are saddled with a couple which is fighting every day, and say in some cases where there is very aggressive and violent daughter-in-law also who's creating menace. That was the purpose, or that was the design behind this judgment which is there. I have no time now to go through each the judgment. But then we have another case which was in the year 2020. Satish Ahuja versus Sneha Ahuja, which is a civil appeal 2483 of 2020 arising out of SLP 1048, in which the courts have taken a different stand. And the Honorable Supreme Court has said that the courts will have to view every case individually to be able to ascertain what amounts to a matrimonial home in respect of a woman who's an aggrieved woman, as we know, who's an aggrieved woman in a situation that we are talking about. So I think you should go through these laws, because I think we are running short of time, and I do need to deal with certain other properties also. Certain other certain other cases also, to be able to do that. So in the residence orders which are passed, they are, the nature of the order would be not to dispossess the lady. Number two, direct the respondent to remove himself from the shared household. Number three, restrain the respondent's relatives from entering. Number four, not to alienate or dispossess. Number five, not to renounce his rights in a shared household. Now, what happens is, if, pausing here for a moment, the house stands in the name of the, say, the father and the son. Son is the husband in this case, but let's say the father and the son. The son is married and the daughter-in-law is there. So when she can stay in the house, because the 50% or whatever the share it is, it's a joint house and her husband's name is there. Now, because he wants to defeat the claim of the wife, or to teach her a lesson, or to make, or to dispossess her, he gifts his share to his mother. And he says, okay, now the house doesn't stand in my name. I have gifted it to my mother. So even this eventuality is covered by the act, and it says that not to renounce the rights in the shared household, which means you cannot gift it away, or you cannot alienate, or you cannot transfer it to any other person at the cost of depriving your wife of her rights in that shared household. Now, rights could be of any nature, of staying there or securing alternate accommodation or alternate rent, etc., which is there. But you could injunct the husband from renouncing his share in a shared household. Lastly, not to direct the respondent to secure the same level of alternate accommodation. If the husband does not have any things which are there, then to direct him to give similar. So it cannot be that you're living in a 5-bedroom apartment and all of a sudden the husband says, no, we have to go and stay at far away in some of the suburbs and stay in a 1-bedroom apartment. Now that difference cannot be there. It cannot be identical. It cannot be, it has to be a 5-bedroom again. But it has to be similar to the standard of life, where the dignity and the standard of life for the wife is not compromised because of the ill motives of the husband or the in-laws. Now, in these residence orders, you will have to appreciate one more thing which is there, and which is, I'll share this with you because this has helped me in one of the matters where I was appearing for the husband. The wife made an application under the Domestic Violence Act in a divorce petition filed by the wife, in which she asked that the husband be directed to provide me with a house. And because he's filed for divorce, and I'm staying at the mercy of my parents. And she didn't go under the maintenance or alimony part, but she went under the DV Act. Now, it says that the residence orders can be passed, which I've just read out to you. What are the kind of residence orders? Now, in the same clause, there is one more section which says that while making an order for residence, the magistrate may impose on the respondent obligations relating to the discharge of the rent and payments, having regard to the financial needs and resources of the party. So, pausing here for a moment, that if a woman has resources of her own and she is able to take care of her residence in an interim period, then that could be one of the factors the courts would consider, whether they should penalize the husband by doing it or whether she's self-sufficient. So in this case, which I did was, I appeared for the husband and we had filed for divorce, and the divorce petition was going on for 5, 6, 7 years, as you know how it happens in the trial courts. So in between, the lady came and she filed a application under the Domestic Violence Act, not for any other thing, but the relief she sought was a residence order, asking that he should be directed to provide a residence for me, or ownership residence of a 2-bedroom apartment, or give a rent of say 75,000 something was asked for rent, and alternate accommodation. So I opposed this, because then we asked her to produce all her income documents, her income tax. She was a working woman. She was doing very well for herself. She may not have had an apartment to her name probably at that relevant point of time, but she had sufficient funds which are there. So I as the lawyer pointed out to the court this particular clause which comes in section 19, which is subclause C in the proviso, that you have to have, the courts will have to have regard to the financial need and the resources of the parties. So it is not only of the respondent, but it is also of the parties. And whilst doing this, she was asked to produce all her income documents, etc. And the courts learned that she had sufficient money of her own and there was no need to pass anything. So the courts do not necessarily pass all orders in favor of women, but they do examine critically each and every case that comes up with reference to the case which come with reference to the individual case that comes up before the court. Now you have to realize one thing, that though this is the law meant for the benefit of the women, uh, unfortunately in our practice we find that in some cases, like section 498 here, the A has been abused, misused for ulterior motives or greed or for legal extortion. Some of the provisions of this Domestic Violence Act have also been abused by certain section of the women in the society with a view to make either a larger or a better deed, and which, in my opinion, amounts to. So these are not genuine cases. These are not cases which I all along discuss with you right now. These are cases made with an ulterior motive. And they are only made with an ulterior motive because it means they want to be unjustly enriched by using or abusing the provisions and making certain things. Now, that is where the magistrate or the judge, whoever deals with it, has to take into consideration. As they say, you have to separate the wheat from the chaff. So, what is genuine has to be dealt with by the courts, which is a chaff, which is just a sham, and which is smacked with malice and ulterior motives and malafide. The courts will surely not grant relief to such women. One of the interesting factors of this is also, as you see further, there are maintenance orders which are passed. There are orders for child custody. There are orders for visitation. There are also orders which is for the compensation. Now, if you go to section 20 of the Act, section 20 of the Act deals with what is known as the monetary relief. So what are the reliefs that a woman gets under this Act? Monetary relief: while disposing of an application under subsection 1, the magistrate may direct the respondent to pay monetary relief and expenses incurred for the loss of earnings, the medical expenses, the loss which is caused due to destruction, damage, or removal, the maintenance for the aggrieved person as well as her children in an order in addition to the order of maintenance under section 125 CRPC. These are the monetary reliefs. They should be adequate, they should be fair and reasonable and consistent with the standard of living. And the magistrate will have the appropriate power and to order an appropriate lump sum or a monthly payment. So at the end of it, so when I started my address to you, I said that if these are similar problems or the similar issues that a woman goes through, then why is there a 498 and what is the need for a protection of protection of women from the Domestic Violence Act? That is the reason I said that these are civil in nature, there are damages, if may call it. The word used in the act is compensation. While under 498A, they are penal in nature and they are, excuse me, they are penal in nature, and the law follows its own course under the criminal law. So that is the difference between, so there is cruelty on the woman here, there is violence on the woman there is different class, but the Domestic Violence Act has a larger implication and it deals with a whole lot of cases. Now I think I have overshot, am I, or can I just deal with one aspect of it, madam?
Yes, madam. Go ahead.
May I take 5 minutes more? I know I have overshot.
Surely, surely, madam. It is very interesting.
Thank you.
Our students are really, they are enjoying this lecture.
Thank you so much. Thank you so much.
Yeah,
So I
please.
just wanted to deal with one more aspect of what is a live-in relationship. When I started addressing this, I said any woman, any lady who is an aggrieved person. And I said the reason why I said that it is any woman, it also means not necessarily the wife. So a whole lot of cases came up before the Supreme Court, in which cases of live-in relationships came up. So what are the rights of the woman under the DV Act in a live-in relationship? So give me just 2 minutes and I'll say. In many countries, there has been a broader understanding of the idea of a couple and a family, which can be seen in the legal recognition of a prenuptial agreement, cohabitations, civil union, and domestic partnership. We're talking about overseas. But in India, the DV Act included within its purview live-in relationships under which a woman was in a relationship in a nature of marriage can approach the court, though not legally married to the husband, to the man, if she is abused. It protects the female partners from domestic violence, and such partners can claim monetary and other relief. Since it covers economic abuse, it also affords protection for women in violation of their financial rights. Now, how do you define live-in relationship? Because there is no concept, there is no definition of a live-in relationship which has been mentioned. Now, there are two cases that went right up to the Supreme Court. One is the case of D. Veluswamy versus Patachi Amal, which was in the year 2010. And I mean, for those who want the details, it is D. Veluswamy, who was the appellant, versus D. Pachai Mal. This was decided on 21st of October 2010, which is it's a reported judgment, and the citation is AIR 2011 Supreme Court 479. I'm just taking a couple of more cases also. The other case which I will be sort of, which is similar or akin to this, is Indra Sarma, INDRA, Indra Sarma versus VKV Sarma, 2013, 15 Supreme Court cases, 755. Now, what happened in these cases was that a woman was in a live-in relationship and she was and then something went wrong in their relationship, and which I said earlier, which that she was a second. She went to the courts and she told the courts that I'm in a live-in relationship. I'm not married to him. But as a result of which, I need protection because he made me believe we've been living together, and now all of a sudden he has stopped providing me. The courts examined, and this matter came right from the lower court to the high court to the Supreme Court. Now, what the courts have held in both these matters, and they are the findings are pretty similar in Indra Sarma and even this Veluswamy's case, was that to constitute a valid live-in relationship, what are the conditions and the terms which are there? Can it be a short stay? Does it have to be a decent amount of days and months that you have to live together to be able to term it as a live-in relationship? Does it have to be frequent visits or lack of frequent visit, which amounts to it? All these things, and what is otherwise a valid live-in relationship? And the courts, I'll read out what they have said, but I will just tell you in short first. The courts have said that a person to be in a live-in relationship or the couple to be said to be a live-in relationship should be in a relationship for a reasonable period of time where their relationship is akin to marriage. The word is AKIN, which is akin to marriage, but not married. So, as if I'm living with a man and the, the people around recognize us as a couple, but legally we are not married, and only then it can be called a legal relationship. But one more interpretation was given by these two judgments, which is there, that they have to live as a couple, that if otherwise if they marry, they could be husband and wife. Now that is a difference that you will have to appreciate, because the Domestic Violence Act, please remember, and this is very important for everybody to understand, the Domestic Violence Act is not permitting adultery to be taken advantage of by the people. Now, the reason I'm saying this is, so the courts have held, the highest supreme, that is the law of the land today, that if a man and a woman are living in a relationship, if tomorrow they decide to get married, they should have the legal capacity to get married. What is the legal capacity to get married? Number one, that either of them should be single. Single means either they are not married or divorcees or widower, etc. So you have the capacity to marry, and your age is, say, 21 and 18, as we all know under the act. Now, in this case, what had happened, in both the cases, what had happened was that the man was living with a woman, but he had abandoned his wife and he was a married man. Now, the courts have held that this is not a valid live-in relationship, because if a woman is living with a married man who has not divorced his wife, but either abandoned her or whatever he may have done, tomorrow this couple cannot get married. And as a result of which, they declined to give her any of the benefits which were there. And the reason for this was that the law is not in favor of promoting adultery or adulterous extramarital relationship. Tomorrow you cannot be that somebody leaves the husband, starts living with a man, and then has a relationship which goes on, and all of a sudden says that okay, she's my wife, but you are not a wife because you you do not have the legal capacity to get married. I'll just tell you one example which I did myself. This was in the case of uh, again, it was a very celebrity case, but I will not take the names which is there, where a very well-known superstar was there. He was married, he had two children, but the children were grown up. The wife had separated from him, so I don't want to get into who abandoned whom, was separated from him. And they were living separately. It was public knowledge because they were both public figures, and they were sort of, it was all over the press. At that point of time, there was a lady who came into the life of this man, and the lady was living with this man, with this celebrity superstar, and who was no longer active on the celluloid, but who was still had a big name. She was living with him for 3-4 years, so I don't remember exactly. Then there were disputes that arose between her and the man, not on account of the man and her, because he was ailing and he was unwell and he was about to die. So all of a sudden, according to this lady who was in a living relationship, let's call her Miss X. Miss X felt that her separated wife came in, children came in who had all abandoned him, and she was the one who was taking care of him when he was unwell and etc. and being in a living relationship, and she was seeking compensation. So they all came in and they said, in the meantime, what happened while this was happening, this superstar died. Then the case, obviously the heirs were brought on record. The heirs was the wife and the other, and notice was issued to them. They all came and said that she was not in a valid living relationship because this star had not divorced his wife, and they were just living separately. So in the eyes of law, they were still husband and wife. And if the husband and wife are the relationship is there, then a husband cannot get into a valid live-in relationship with a woman because he's still a married man. And Indira Samra and Veluswami's judgment came in their favor. And I was representing this woman who had really, in reality, served and looked after the star which was there. But the courts held that there was no valid relationship between me and the star, and a result of which my claim or my petition was dismissed, and the notice which was issued to the in-laws, to the daughters and the estranged wife or the widow now of the superstar was sort of quashed and set aside. The matter is now in the Supreme Court. So obviously that is why I'm not taking the names. The matter is still to be decided and sub judice. But if this is the law which prevails, then the concept of live-in relationship will have to be examined by the courts in a manner which will also include genuine cases where people are in a relationship. But the law says that if you know that he's a married man and a separated man, and still you choose to have a live-in relationship with him, then you have to bear the brunt of the law, because the law does not recognize such live-in relationships. And lastly, last 30 seconds, the courts could be the family courts and the civil courts along with the magistrates court, and which is mentioned in section 26. So you could have proceedings filed in some other proceedings which are pending in the civil court or in the family court. You could file for domestic violence proceedings in those courts also. So the subject is very vast, the nuances are varied, and the cases, each case is different from the other. So I know I've overshot my time. I apologize to the organizers, Madam Rajeshri and all others for overshooting. And but I was a professor in the Department of Law. So unless there was some kind of a thing, we could just go on and on. And we are all so fond of sharing our experiences. So thank you for giving me this opportunity of sort of explaining my point of view and helping rather taking you through the journey of what the Domestic Violence Act means for the protection of women, what are the nuances and what are the different factors that the courts take into consideration whilst granting any of these orders. Thank you so much and I'm happy to sort of have any interactive thing that you feel is necessary for this. Thank you so much.
Thank you, Madam Advocate Mrunalini Deshmukh, for a wonderful lecture delivered today on the topic of domestic violence and women empowerment. I highly appreciate the way in which you make it so interesting. Oh, means we don't think that you should stop talking, and it should just go on and go on and go on. Even our students and teachers and principals who have joined this gathering, they are also enjoying this virtual meeting lecture, and that is why that was the purpose to organize such lectures. And as a law department, you are alumni of the department, we feel proud about it. So, madam, and the way in which you have elaborated, no, everyone likes it. And
Thank you.
that was the purpose. Law department thinks all people cannot come to the law department, but let us go and meet people, have interaction with society people, and create legal awareness in the society at large. I think we have achieved our task in a very correct manner. I appreciate your presence of Advocate Sudeep Pazbola, Vice Chairman of Bar Council of Maharashtra and Goa. I appreciate our co-organizer, Dr. Ranjan Kumar, Dean of Faculty of Law, Mahatma Gandhi Kashi Vidyapith, and my colleague and friend, Sheetala Gavan, who is a principal of BCT Law College. Three of us, we wish to create legal awareness, and that is why, Madam Lloyd, your doorstep mission is started by the law department, and we are very happy by looking at the interaction and participation of around 400 to 500 students, professors, and principals. Now, my personal thanks to you, madam, for accepting our invitation in spite of your busy schedule. Now, just even though lecture was so much interesting and for I think more than 1.5 hour continuously you are talking, but student wish to interact with you. So 5 minutes we will have interaction. So a floor is open for students and participants. You can share your interactions and raise your hands.
There are a couple of hands raised. Firstly, Miss Poonam Chavan.
Good evening, ma'am.
Good
It
evening.
was very interesting lecture, and I just have one question. That suppose in living relationship, if a lady who is a aggrieved lady, she doesn't know that the man is whether man is married or not. Like later on, she comes to know that he is married, and then what kind of protection she gets?
But which is, sorry, Poonam, that's exactly what I said. That there's a similar situation which I told you about these two Supreme Court cases, which have laid the law of the land. Ignorance of law is not an excuse, as you know. Now, to say that I was not aware that he was a married man, and it may have been a genuine case. I'm not saying no. But then, if there is a law which is prevalent, ignorance of law is not an excuse. Then the option that you have is to go under 420 IPC, I would suggest, for the cheating that the man has done or the fraud that he has played on you of not disclosing the fact, and that you in good faith enter into it. But the law, as far as living relationship and the rights are concerned, we are still governed by these two judgments which I have told you.
There is another question from Palve Krishna Jagannath.
असं आहे का आपण डोमेस्टिक व्हायलन्स बाबत आहे ना व्यवस्थित माहिती एकदम समजेल अशी माहिती पूर्ण दिली. फक्त मला एक विषय होता की आता सेक्शन 36 बाबत आपण माहिती नाही दिलेली, तर तेवढं एक्सप्लेन केलं तर बरं होईल मॅडम. कारण मला माझ्या माहितीतली एक अशी केस आहे त्या एका लेडी विरुद्ध 494 495 दाखल आहे, तरी त्या लेडीने कोर्टामध्ये मी त्या व्यक्तीचा त्या मुलाची पहिली वाईफ आहे असं दाखवून त्याच्या विरुद्ध गुन्हा हे केलं, डोमेस्टिक व्हायलन्स मध्ये हे केलं, अपील दाखल केलं. त्या मुलाला नंतर माहिती झालं की ही माझी पहिली वाईफ नाही, हिने अगोदरच लग्न केलेलं होतं, तरी कोर्टाने तिच्या विरुद्ध त्याच्याकडे हे मागितलेले आपल्याली खावटीची केस दाखल चालू आहे.
नाही, तुमचा प्रश्न काय आहे की सेक्शन 36 जो आहे डोमेस्टिक व्हायलन्स ऍक्टचा, तर आपल्या सगळ्यांच्या याच्यासाठी त्याला वाचून दाखवते. दिस ऍक्ट इज नॉट इन डेरोगेशन ऑफ एनी अदर लॉ. बरोबर. The provisions of this act shall be in addition to and not in derogation of the provisions of any other law for the time being in force. It means this clause stipulates that the provisions of the proposed legislation shall be in addition to. तर हा जो कायदा आहे सेक्शन 36 मध्ये जो दिलेला आहे तो त्यांनी केलेला हा स्पेशल एनॅक्टमेंट आहे, आणि हे स्पेशल एनॅक्टमेंट केल्यामुळे त्याचा जो आहे त्याच्याशी बाकीचे जे एक्झिस्टिंग कायदे आहेत त्याच्यामध्ये इट इज नॉट इन डेरोगेशन किंवा त्याच्यापेक्षा कमी नाहीये, एडिशनल दिलेला आहे. आणि हा कायदा बायकांच्या फेवर मध्ये असल्यामुळे, कारण इट इज फॉर द प्रोटेक्शन ऑफ विमेन. एक गोष्ट मी बोलण्यामध्ये इंटरॅक्शन मध्ये आय फॉरगॉट टू मेन्शन is unfortunately this is only for the protection of women, and since we are talking about it, but I personally feel that this law could be made gender neutral. कारण काही काही केसेस, एक्स्ट्रीम केसेस मध्ये आपल्याला असंही दिसण्यात येतं की काही काही बायकांनीच पुरुषांवर केलेले फिजिकल व्हायलन्स, इमोशनल व्हायलन्स वगैरे असू शकतो. परंतु तुमचा जो प्रश्न आहे सध्या की मी 36 बद्दल बोलली नाही, त्याच्याबद्दल मी एवढ्यासाठीच बोलली नाही कारण की हा जो कायदा हा स्पेशल एनॅक्टमेंट आहे, त्यामुळे तुमचे बाकीचे जे हक्क आहेत बाकीच्या कायद्यामध्ये, जर तुमचा मेंटेनन्सचा असेल समजा 24 मध्ये, कस्टडीचा असेल, ओव्हर अँड अबव्ह दॅट हा कायदा तुम्हाला उपयोगात आणता येईल, हेच ह्याचं म्हणणं आहे.
मॅडम त्याच्यामध्ये असं मराठीत जेव्हा आपण वाचतो ना त्याच्यामध्ये असं लिहिलंय का हा कायदा जर बाकीच्या कायद्यांना न्यूनत्व आणत असेल, म्हणजे त्या कायद्यांमध्ये हे करत असेल, तर हा कायदा लागू होणार नाही असं मराठीमध्ये लिहिलेलं. माझ्यासमोर ऍक्ट आहे.
नाही बघा ना, मी तुम्हाला आपण वाचूया ना इंग्लिश. दिस ऍक्ट इज नॉट इन डेरोगेशन ऑफ एनी अदर लॉ. त्याचा अर्थ असा, द प्रोव्हिजन्स ऑफ दिस ऍक्ट शॅल बी इन अडिशन टू. अडिशन म्हणजे अधिक होईल, आणि नॉट इन डेरोगेशन. So I think it is very clear, at least the act that I am reading. I think we can have a personal discussion on this.
Yes.
Because this is a very individual case, but I'm happy to have this. But I have read out the section for the benefit of all they are present over here. And I think it is very clear from the English interpretation.
Very well explained by you, madam. Yeah, no doubt. Any other question or comment? Savita Malhotra.
Madam, I'm your student, ex-student.
Oh, hello.
Business law in SY become student. I wanted to hear you from hours together. I can hear you,
Oh,
and
thank you.
because of you only, I got a scholarship in university in your paper.
Oh, thank you so much. Thank you so much.
Yeah, it's my pleasure to hear you again and update myself. I
Thank
can
you.
hear you for years to hours together. Thank you, ma'am. Thanks a lot.
Thank
And
you.
here,
Thank you.
I'm also.
Mr. Deepak Kamble.
Ma'am, I will first of all thank you very much because this is really serving the purpose of a lot our this doorstep. So
Yes.
please forgive me for my little lengthy question. There's a 4-line question, so I will go to the straight to my
One
question.
question. Now make it brief, no, Deepak,
Yes, yes,
please.
yes,
Make
yes,
it.
yes, 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 ma'am. Sorry. So nearby I have one case that father-in-law suspect his daughter-in-law of extramarital affair. Okay, but husband have no such suspicion issue. Because due to such suspicion, the father-in-law intend or threatens to sell his house to teach her lesson. So husband is in farming, so they have no good income. So can this daughter-in-law expect any relief or justice?
If the husband supports her, though he will be made a respondent by the number one, the father-in-law can, so the wife can go to the court of a domestic violence court and seek an injunction that it is her matrimonial home. She could also go under the Specific Relief Act saying that she should not be thrown out and because this is her matrimonial home. And she could, it could be then, she could make the father-in-law and the husband the respondents for it. The husband could come and say that I have no intentions of throwing her out because if he believes that the wife is not doing any of those things, then the father-in-law will have to give, and then this will have to be tested on the touchstone of evidence, whether it is any, it's a collusive suit, whether it is there is any of the genuine rights of the aggrieved person which are compromised, or lastly and more importantly, that whether the husband is also directed by the courts to secure alternate accommodation for him and his wife, as an injunction cannot be sought on some property which could be a matrimonial home but not owned, or husband has no right title interest in it. So I can't really give you an answer to a specific individual case. All the facts will have to be studied. What is the background? Who
Correct.
did it? All that. So any advice given like this only on 3 or 4 lines would be improper on my part, because I need to
Correct.
understand the entire thing. That's the way we deal with it. I can't give a symptomatic treatment as they call it. It'll have to be a well read out. So please appreciate where I'm coming from.
Manda Chavan.
Yeah. Good evening, ma'am.
Yes.
I have case in hand which is like this. It's on living relationship. The female, she is a divorcee. She has a child. Okay. She has been divorced 10 years back. Okay. And she is in love, madly in love with one of the person who is married. He has already informed everything about, he's married, that he's married and things like that. And he also was applying for divorce, but then due to this COVID, the divorce didn't happen. And now this both husband and wife, they are not taking, they decided they will not take divorce. And this girl, she is madly in love with this person. So is there any relief for this female? She can stay in live-in relationship, and can she get some benefit for her child from this man or something like that, ma'am?
So please understand that number one, I'm not a love guru, so I cannot opine on what a woman should do. She's madly in love with a man who has decided to stay back with his wife, and probably she feels that he has cheated her. Secondly, as far as the child is concerned, there is no claim that a child can make against that man. He is not the biological father. And
Correct.
just because the woman is having a relationship with that man, and in the good days, the man may have said, I'll take care of your child. There is no legal responsibility or duty of this man to take care of the child that is born to her from some her previous relationship or her previous marriage. Now, ultimately, when you do this, there is a leap of faith that you take. Unfortunately, not in all cases you succeed. In some cases, you are met with these roadblocks where the husband, where the man who she knows. Number one, she cannot get into a relationship with a man who's a married man if she knows that he's a married man. because that is not accepted in law as a valid or a legal living relationship. So there she's making a mistake. So if she's not supposed to do what she's not supposed to do, then how can she expect any relief from this? And just because she loves him, I mean, I respect her emotion, but that's not what the law looks at. The law looks at facts and what are the legal obligations and duties. So in this case, she will have to be advised in appropriately what she should do. Is all that I can say at this point in time.
Ma'am, but the man had promised her when he was taking divorce that he will get married with this one, the female who is madly in love with her. But now the divorce has been postponed or it's been cancelled. So now he is not ready to, marry. But then, yeah, they can stay, whatever the relationship is. This is what the statement is right.
I can't give a legal opinion on what is to be done if a married man promises a woman that he'll marry. Please understand that. I mean, there is
Yes.
no. As a friend, I may advise you something, but as a lawyer, and especially on this platform, I can never advise you something which is not within the ambit of law. It's improper, incorrect.
Okay, ma'am.
Thank you, Honorable Chief Guest Mrunalini Deshmukh, Madam, Advocate, High Court, Bombay, for answering to all the queries of the participants.